Good morning, everyone. Good afternoon. Good brunch. Welcome. It's Saturday. It is the weekend review, and I am your lone wolf, Usul. Thank you very much for hanging out with us this morning, and we have a whole lot to cover today because it's been a huge week in the court community. We're going to start off in Kent. I don't know if it's Kent County or Wexford County. I'm not sure where it is actually, but it's Judge Wiggins is who it is, and he's dealing with a keyboard warrior who's been threatening city officials, and boy, he's not happy about it. Then we're going to visit Clayton County, Georgia with Judge Hayward, where we're going to hear about a romance scam gone wrong, and she's going to adjudicate over it. And then we have a whole week worth of Simpson review, ladies and gentlemen. We're just going to start from the 4th and move to the 5th to the 6th, and we're going to look at a lot of everything that went on in Simpson's court, and we're going to do the same thing for Judge Stevens. And ladies and gentlemen, we're getting that started right now, and I'm here with you. Is how we do it. Hope everybody's having a great morning. I'm your lone wolf, Usul. We do these get-togethers every Saturday at noontime Eastern, 11 a.m. Central Time. So we're doing a little bit of a brunch. We're all just going to get together. We're going to watch all these cases. We may have seen some of them. We may have not seen some of them, but we're all going to comment on them together, and maybe later they'll become their own little independent video. But ladies and gentlemen, everything gets started right now.
Okay, court calls the people of the state of Michigan versus Jamie Andrew Moore. This is case number 25682 SM. Appearances, counsel.
Joanne Carey for the people.
Robert Hartzell for Mr. Moore, who joins with the table, Your Honor.
And we are set today, you may have a seat. We are set today for a plea and sentence. I know we tried this back on the 22nd, and some questions came up, in particular, the possibility of double jeopardy. I have reviewed and done my own research. I don't believe that applies here, but I'll leave it up to counsel to argue otherwise if they feel as though that's necessary. Mr. Hartel?
I don't feel additional allocution on that is necessary, Your Honor.
Ms. Carey?
Or do I?
All right. So it's my understanding we have a plea agreement in this case. And my understanding is that the defendant will plead no contest to all counts as charged. Is that correct?
Yeah.
That would be the understanding.
All right. Ms. Carey, I believe I returned your exhibit last time we were here. Actually, I think Mr. Carnes was covering you. Do you have that? Mr. Moore, while she's looking for that, will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. It's my understanding then that you'll be pleading no contest to all counts 1 through 4. Count number 1 being computers using a crime to commit an offense with a maximum imprisonment of 1 year or less. That is a 1-year misdemeanor and or a $5,000 fine, reimbursement to the government for expenses incurred, and consecutive sentencing may be imposed for the underlying conviction. In count number 2, you'll plead no contest to telecommunications malicious use. Regarding Ms. Carla Filkins, that is a 6-month misdemeanor and or a fine of $1,000. And count number 3, you'd plead no contest to telecommunication services malicious use. Regarding Marcus Pesha, that is a 6-month misdemeanor and or a fine of $1,000. And then in count number 4, it is alleged, or I'm sorry, you would plead no contest to telecommunications malicious use in regards to Renee Pesha. That again is a 6-month misdemeanor and or a fine of $1,000. Is that your understanding of how the case will be resolved today?
If I may, Your Honor, just to reiterate, there's also the agreement that the other cases would not be pursued.
Correct. Thank you for that. And so additionally, there will be no charges arising out of the Wexford County Police Report 83-25-00625 or the City of Cadillac Police Report. Ms. Carey, do you have that number? It ran into other letters on my sheet and I can't read what it says. I know it's a 25, I want to say 804 maybe? 884.
It's the same. It would have been 1.
Okay, so it all arises out of the same occurrence?
Correct.
All right. Mr. Moore, is that now your understanding of the plea agreement?
Yes, sir.
And is that a full and accurate recitation of the plea agreement?
Yes, sir.
And I know we went through this last time, but I still need to cover it today. Did you read and sign the advice of rights form, talked about your rights to an attorney and your rights to a trial?
I did, yes, sir.
Did you understand those rights?
Yes, sir.
And do you understand that by entering a no contest plea today, you'll be waiving those rights and you won't have a trial of any kind?
Yes, sir.
Has anybody promised you anything in order to get you to plea today other than the agreement?
No, sir.
Has anybody threatened you in order to get you to plea?
No, sir.
And is it your own free choice to plea today?
Yes, sir.
Now, do you understand that by entering a no contest plea, that it will allow the court to review a in this case, a police report, which was already admitted as People's Exhibit number 1, I'll be able to use that to determine whether or not there's a factual basis and whether or not, and to use that for sentencing purposes. Do you understand that?
Yes, sir.
Additionally, the reason for the no contest plea is for potential civil liability. So if any person's listed in the complaint decides that they want to sue you civilly, a guilty plea could be used against you. This would allow you to accept the responsibility as if you are guilty without saying you're guilty. Do you understand that?
Understood. Yes, sir.
Then to the allegation that on or about January 21st, 2025, here in the city of Cadillac of Wexford County, in count number 1, that you did use a computer to commit a crime with a maximum imprisonment of 1 year or less, in particular, malicious use of a telecommunications device. How do you plead?
No contest.
To count number 2, malicious use of a telecommunications services in regards to Carla Filkins. How do you plead?
No contest.
In count number 3, malicious use of a telecommunications services in regard to Marcus Pesha. How do you plead?
No contest.
And in count number 4, malicious use of telecommunications services in regards to Renee Pesha. How do you plead?
No contest.
Last time we were here, I had the opportunity to review People's Exhibit number 1. Counsel, do you believe that People's Exhibit number 1 forms a factual basis in which to accept the plea,
I do.
Yes, Your Honor.
and that the court rules have been complied with?
Yes, sir.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. In particular, Mr. Moore, I find that back on January 21st of this year, you had sent messages, and those messages were threatening in nature. I'm sorry, People's Exhibit number 1 also includes the Michigan Department of State Police, incident number 6441025. In particular, to the message that was sent to Ms. Filkins, it states as follows: "You're gonna do something about the water in Cadillac, or what, you stupid dumb bitch? You'll be lucky if one scary night someone don't come to your home and pull you from your sleep and pull you to the streets and put a bullet in your head, you corrupt dumb bitch." Additionally, there was a message sent to Mr. Pesha that says, "Just seen your wife reporting city council meetings on Facebook. You, sir, and your dumb little bitch of a wife should be pulled from your house while you sleep and a bullet put in your head. You're scumbag, corrupt loser, bitch, who should be shot dead in front of the whole community of Cadillac just to show an example. Your wife is a scumbag, corrupt loser, or bitch too, you stupid fat fuck." I apologize for the language that was used, but I believe it's appropriate to place that language on the record to get the defendant's full intent when sending those messages. It's also my belief, based on the reading of the reports, that those had come in through a Facebook Messenger, which would meet the requirements for use of a computer to commit the crime. And additionally, I also find that these messages were sent to or regarding all persons involved, and that all persons involved would have seen these messages, and that they were sent with the intent to terrorize, frighten, intimidate, harass, or disturb the peace of each of these individuals. Additionally, I find that based on my reading of the report and by defendant's own admission, let me just find this here. He also admits to sending the messages and classifies them as an emotional overreaction, but had no plan to follow through with the threats. Well, he had no plan to follow through with the threats, at least as he describes. I do find that based on recent case law arising out of the Michigan Court of Appeals and the Michigan Supreme Court, I believe that these messages do show the intent of sending the messages was to threaten, terrorize, harass these individuals, and that the defendant knew that when sending those messages, that is the effect that they would have. As such, Mr. Moore, I find you guilty in count number 1 of using a computer to commit a crime with a maximum imprisonment of 1 year, which is a telecommunications services malicious use. Count number 2, telecommunications services malicious use regarding Ms. Filkins. Count 3, telecommunications malicious use regarding Marcus Pescia. And count 4, telecommunications malicious use regarding Renee Pescia. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea, in that a guilty plea could be used against him in a potential civil liability case. I also find that the plea is knowing, voluntary, and accurate. Pursuant to the plea agreement, those additional cases will not be brought. Ms. Carey, are we able to sentence today?
We are, and I have 2 of the victims here who would like to speak.
All right. Who wants to go first? Mr. Pescia, could you just state your name for the record, please?
Marcus Pescia.
And what is it you would like the court to know?
Thank you, and good afternoon, Your Honor, and officials of the court. Your Honor, words have meaning. Words can be weaponized, and words have consequences. You're here today because Mr. Moore read words on a social media platform posted by people that, in my opinion, was published to create an environment rife with chaos and mayhem, an environment to facilitate a crisis that does not exist by the malicious spreading of lies, misinformation, and attacks on my and my wife's character and credibility. Words have meaning. They can be weaponized, and they do have consequences. Mr. Moore could have read those words and reached out through a variety of methods to contact me, or a member of my staff, or a member of any number of state agencies, or even the feds, to gain information. Information that would provide the factual truth of what was being, in my opinion, falsely propagated on social media. However, Mr. Moore did not reach out to learn the truth. Rather, Mr. Moore directly messaged me on the social media platform's messaging feature to threaten me and my wife. And further, as I understand, also posted his profoundly alarming and disgusting threats in at least one publicly available social media group for an unlimited number of people to see, share, and spread. All things that could have led to, and still could lead to, disturbingly violent outcomes. Mr. Moore's actions have detrimentally impacted my life and my wife's. Mr. Moore's actions have also had a negative effect on my children, my family, my friends, and even colleagues. Mr. Moore's actions have caused stress, anxiety, and an emotional roller coaster of feelings. The shock and horror to see words about my wife and I being drug out of bed in the middle of the night, dragged through the streets, shot in the head, and displayed in the town square are evil, and they do have an impact. Stress, sleepless nights, being on edge, they're still with me. They're still with my wife and others. Behavior Mr. Moore has exemplified, it needs to stop. It is not okay, nor is it something that can be simply forgotten, forgiven, or excused. Words have meaning, words can be weaponized, and words have consequences, and I appreciate the court's time. Thank you.
Thank you. Ms. Filkins?
Good afternoon, Your Honor and officials of the court. I came today not with a prepared statement, but I would like to speak from the heart today. Words do matter, and Jamie Moore chose to use his words for harm and for evil. And that impacted my family, my 85-year-old mother, my son, who is a Marine, my other children, my grandchildren. It impacted me. It was a game changer for me. I served the city of Cadillac for 11 years with tremendous honor. When I received a death threat for caring for my community over things that Mr. Moore read on Facebook and other social media that weren't necessarily true, people were just putting their words out there because that's what they can do on social media. And on January 21st, the very first thing before I walked out of the house that morning, I received that message from Mr. Moore on Facebook chat. And I was terrified. I called my husband home. I called the public safety director, and we spent the rest of the day not planning for our business that we needed to conduct that evening for the city of Cadillac. We spent our day trying to, first of all, understand what was happening. And how could we take care of our community with these types of threats coming forward to us? It wasn't just about us. It was about people that are out there that can do such horrendous things with their words. And I just want the court to understand what that's done. Thank you.
Thank you, Vogt. Elocution, Mr. Hartel?
Yes.
Well, first of all, I had ordered a pre-sentence investigation report on this. Did both parties receive that?
I did.
Mr. Hartel?
I did as well, Your Honor.
All right. Elocution?
Yes, thank you, Your Honor. Anytime there's civil liability possibility for the no contest, I'm obviously a bit cautious to overly allocate. However, I have had discussions with my client quite a bit about the situation. I would ask the court to equally factor in the goals of whatever punishment is given today. I believe that with supervision, any concerns the court may have for education of my clients, public safety, can be incorporated into terms of that probation. I realized that recommendation for a jail sentence was in the PSI, and the reasoning was explained in there as well. I certainly asked the court not to give a higher amount than was recommended in the PSI. I realized the court could, but I would ask the court still to consider just probation in this situation. I believe my client has done well on bond. I know there was some concerns that the people had mentioned that were being dismissed as part of this plea. We have our own position on whether he was or was not guilty of those particular things. I'm glad they're dismissed. You don't have to worry about it. My point is, he's always come to court. He reported to the PSI on time. He's a hardworking individual. In fact, I'm very proud to be able to say this part because I was proud of him when I saw it. He came straight from work to that PSI interview. He lives in Roscommon. He was still wearing paint covered pants and other clothing covered in work materials. He was a bit embarrassed. He didn't want to shake my hand. And I thank him for not getting me covered in paint, but he's that dedicated both to doing what the court needs him to do and providing for his family, being a hardworking, productive member of society. I have no idea if the underlying inflammatory situations were true or not. I know there were some statements about that as far as concerns in the community for what may have sparked the exchanges, but that's not what we're here for today. We're here because of the plea that was taken. And I would ask the court to factor in the factual basis with the no contest included the part where my client told law enforcement that he did not have the intent to actually follow through. I realize that doesn't change. There was enough elements to meet the factual basis for the plea that was taken. But stuff is on a scale. If somebody authentically was trying to harm people, I don't doubt that that would be something the court should additionally factor in. I just asked the court to factor in. That does not appear to have been the case here for the appropriate amount of weight for that. My client has made written statement that he would like to say to the court when the time is appropriate. I went over it with him. I believe it's appropriate for him to say to the court. He does have family here for moral support. They have been supportive of him throughout these procedures. I don't doubt they would support him no matter what the court does for punishment. But I know he wants to be there for his wife. He wants to continue to maintain that business. And he has a few other positives that he would like to say to the court. And again, I made sure that they don't destroy the purpose of the no contest.
Thank you. Ms. Carey?
He was authentically trying to harm, and he did. Mr. Pesha and Ms. Wilkins were harmed by that. Their families were harmed by that. As they told me, the community was harmed by that. They had to have extra law enforcement that day, work overtime and come into work to make sure that they were safe. The city council meeting was canceled, and they had to have extra law enforcement present at those meetings because of this. As Ms. Wilkins said, this was a game changer for her. Words do have meaning, and his words were awful. He chose to use awful words to make and did make these people feel threatened, and they still are affected by it. When they receive those, they don't know what his intent is, that he didn't intend to follow through, or that he didn't use the word I as noted in the PSI. They don't know that. What they do know is someone wants them drug out of the house and with a bullet put in their heads. Mr. Pesha's wife said, that's not okay. And it does incite fear. And it's a threat, and it's horrifying, frankly. No matter what the reason or the underlying reason is, or the politics or whatever, that's not an appropriate response. So the people, I appreciate the department's or the probation department's recommendation for 93 days jail with credit for one. I don't think that rehabilitation is appropriate. Again, like the last case, there's no active, I don't know what the rehabilitation would be. There's no alcohol or drugs alleged. So people are going to ask for a jail sentence on count one. The people are going to ask for 1 year and the 6 months in the other 3 counts. Thank you.
Mr. Moore, you have the right to address the court before sentencing. I do realize you've entered a no contest plea, but is there anything you would like me to know?
I would just like to make a statement to the prosecutor, if that's okay.
Direct it to me though, but I mean, look at me while you're doing it, but you can make your statement.
Yeah, you're right. I don't disagree. What I said was wrong. Position I'm in is absolutely ridiculous. It's uncalled for. There are no excuses. I fell short being a man, being an appropriate member of society, and it's pathetic to say the least. Whatever sentence imposed here today will be met with peace and understanding. And I sincerely apologize to those involved, to the courts for the taxpayers' dollars being spent on the proceedings. Thank you.
Thank you. Mr. Moore, I want you to know that while I blame you for your actions, I don't blame you entirely. There is a whole fraction on Facebook that is driving this debate, and they are doing nothing but fueling the fire, throwing allegations out there. I don't know if they're true. I don't know if they're not true. That's not for me to decide. But their actions on Facebook, and you are the perfect example, have created such a divisiveness in this community that I am almost afraid to admit that I am from, afraid's not the right word, ashamed to admit that I am from the city of Cadillac. I have lived here with the exception of 4 years my entire life. I am 5th generation of Wexford County. So for those that I refer to as the keyboard warriors who are out there throwing this stuff out there, shame on them, but also shame on you for biting the bait and doing what you did. I have not seen such animosity in this country with our elected and public officials for as long as I can remember, and as near as I can tell. I'm not even sure we've had it since the beginning of the country, when we used to drag people out and tar and feather them. That is what this reminds me of, and it has got to stop. This is completely ridiculous. It is hard enough to get people to step up to the plate and say, yes, I want to serve. I have been in the position that the two people that spoke today have been in as far as receiving the threats. I've been in that position where I've had to explain to my kids, I'm sorry, you can't go someplace. Or if you go, you need to be on the lookout because some crazy person has decided they're going to post a threat. Well, I don't take my personal experiences into sentencing. I just want you to know that that is the impact that this is having. It is so easy for people on Facebook to just say what they want to say with absolutely no consequence. But unfortunately, or fortunately, depending on how you look at it, you have a consequence because you took it to the next level. And if you think about it, if the people who are putting this stuff on Facebook caused you to post what you posted, the next logical step is that your post was going to make somebody follow through with your threats. Just follow the trail. And that's where this was going to wind up. Thankfully, that didn't happen. We have become so accustomed in you know, there's an old saying that your rights end where my nose begins. Everybody has the right to free speech, but you don't have the right to do what you did. It used to be that people could say what they thought in the privacy of their own homes or amongst friends. But now with social media, that has gone so much further, and people state which would normally be in public or in private conversations, they publish it for the entire world to see. Thousands and thousands of people see these messages, and thousands of people act on them. January 6th is the perfect example of that. But for the grace of God, nobody saw your message and acted with it. I have also read the pre-sentence investigation report that I had ordered. And what I've learned from that is, while you state here today that you take responsibility for your actions, what I've seen in the past, or at least how I interpret that, is that you didn't take actions for your previous incidents. The one you blamed on basically a corrupt law enforcement, and that's why you were charged with domestic violence. The fact remains that case was resolved with domestic violence. I don't know if you pled. I don't know if you were tried. But the fact remains you were found guilty of that, regardless of whether or not there may have been a corrupt judicial system in the process. I have to agree with Ms. Carey. I'm not sure what benefit I get or that the community gets for putting you on probation. What I do know is that by locking you up, that is the only way I am going to protect society and at least protect you from posting these types of messages. I understand that they may have been posted in the heat of the moment, but as has been the theme this afternoon, actions have consequences. And there is no excuse for the actions that you took the time to type out and not just post it on a group, but you sent it to individual people. That took thought. You had to go out and type in those names to send them through Messenger. You would have had to have typed at least 2, maybe 3 messages in order to do that. That's not something that was just decided on a whim, and I'm going to post my thoughts. That took thought. I realize the recommendation in this case from the probation department is for a 93-day jail sentence with 1-day credit. I don't believe I can keep the public safe with 93 days. As such, I impose the following sentences. For count number 1, using a computer to commit a crime for a misdemeanor of 1 year or less, I sentence you to 365 days. In counts 2, 3, and 4, those have a maximum of 6 months. I sentence you to the maximum. Those are to run concurrent with each other. And on each of those sentences, you will receive 1-day credit. There is also a $75 crime victims' rights fee, a $50 state minimum fee, $150 fine. I'm going to change that. I'm going to do a $300 fine on count number 1. Away the fines on the other costs, other counts. There will be a $150 court fee, $150 attorney fee. The 365 and the 180 respectively with the 1-day credit. Mr. Moore, I hope you use this time to contemplate your actions, understand that your actions have meaning. And I also hope you don't use this time to fuel the fire, so to speak. And when you get out, go on a rampage. I'm not saying that you will. I just hope that you don't do that. Because jail hasn't been imposed, you have the right to appeal that decision. If you decide that you want to appeal that decision and cannot afford an attorney to assist you in that regard, you have 14 days to request the appointment of an attorney from the court. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. Do you understand that?
Yes, sir.
Do you have any questions for me?
No, sir.
Ms. Carey, anything further?
No, thank you.
Mr. Hartel?
No, thank you.
All right, we are adjourned on that case.
And now we go to Judge Hayward. She's going to hear about a lady who gave an ex-classmate a whole lot of money. It's crazy. Let's do it right now, shall we?
Devontae June Taylor and Denise Eli Tuckenberry versus Michael Corday McKinney.
Yes.
All right, so Mr. McKinney is not present. I see a Miss Bagwell. Miss Bagwell, are you here for this hearing?
No, Your Honor, I'm not. I'm a summer associate. I was just observing for educational purposes.
I hope it's been educational.
It has, Your Honor. Thank you.
Welcome. All right.
Thank you.
So, Mr. and Mr. I guess Taylor, Miss Tuckenberry, you are here for alleging that there was some sort of fraud.
Yes.
All right, here we go. All right, so you have filed an affidavit and a request for default judgment. Tell me what happened.
Okay. A loan was made to a friend of mine who I hadn't seen in years. We were going to go into some kind of business, into lawn care. Okay. He asked me to loan him my money so he could start the business.
Okay, so hold on. So
Okay.
this is Mr. McKinney.
Yes.
All right, so Mr. McKinney and you haven't talked in years, and then y'all start talking to each other about a business.
Yeah, he found me on Facebook, and we like knew each other from high school.
Okay.
Okay. So he was talking to me about the lawn care business, and it sounded good to me because I know you can make money off the lawn care business. But like I said, he asked me for the loan and I loaned him the money. And when I loaned him the money, we had a verbal agreement that he would pay me back my money.
All right. So you're starting a business with somebody who you haven't seen since high school.
Yeah, we weren't starting a business together. I was loaning him the money.
Okay, so why couldn't he go to a bank?
He has 3 jobs. He works like 7 days a week. He has money.
So then why did he need your money?
Oh, I had money. I had money saved up. So I was going to start a business. But when me and him started talking, it sounded good what he was talking about. He was going to start the lawn care business, and then he was going to come and train me on the lawn care business. I was going to get my own set of lawn care equipment.
Okay, so what was the money how much did you loan him?
Okay, I loaned him $56,000, like from,
wait, whoa, $56,000?
yes.
Did you have anything in writing?
No, just a verbal agreement, and I have like my receipts from the bank and everything else. But 56,000 is not the total amount. The total, go ahead.
Mr. Taylor, how are you involved in this?
He's severely autistic. It's
Okay.
just that some of that money was his money, our money saved.
Okay. All right. So, Miss, why would you give somebody that amount of money with no documentation or anything?
Because by him having all those jobs, he gets a good amount of income.
Which
And
means he could have paid himself, but why would he need your $56,000 plus?
his money was already tied up in things. Like, I was so anxious. I wanted to get this business started, and it can make money. But the defendant,
Ms. Talkin,
yes.
you're one of those people where if you get an idea in your head, you're not going to be dissuaded. And unfortunately, you got an idea in your head that you were going to start a business, and you took $56,000 plus and just handed it to somebody with no documentation.
Yeah, Your Honor, may sound strange, but I've never done anything like that before in my life. I know about scams. I know about romance scams. I know about all kinds of things that happen, but I think I'm under so much pressure taking care of my son. I take care of him totally. You know, he has so many
I
needs.
have a son who's on the spectrum.
Okay. Yeah, it's a lot of stress. And I think that he got the loans because I was vulnerable and I was distracted because I've never done anything like that. And I needed something like I'll be 65 in September. I needed something like to make some money, to like, build for my future, like to have some kind of income. And I had a business plan in mind. It would work, but I just didn't think that he would steal my money. I really didn't think that he would do that.
Report it to the police.
Hmm?
Did you report it to the police?
Did I just set up, this case?
Okay.
Yeah.
All right. So you said that he came to you and asked for a loan. What were the terms of the loan?
Okay. He got the loans and he was supposed to pay me back June the 10th, 2024. Everything, every penny. But
And how much did he get from you?
totally he got like $65,750. And this is why it jumped from the $56,000. I sent him a wire transfer of $9,000 from Wells Fargo Bank to Fifth Third Bank, his bank. Fifth Third stole the $9,000.
Ma'am, banks don't steal money.
Okay, well, they held it. I'll say it like that.
Who
I
told you that?
I have been in contact with Wells Fargo and Fifth Third for like 7 months trying to get my money back from them. Whatever they did with it, it was
You
in
sent-
their system.
You sent it to whom?
I sent it to the defendant.
And now Fifth Third and Wells Fargo are saying they don't have that money.
No. It took me 7 months, and I finally got in touch with the president's office of Fifth Third Bank, and they found the money. But the defendant set it up where it still went into his account. So that's why my $56,000 went to $65,750. Well, I mean, Fifth Third Bank had my $9,000 I was sending to him, and they kept it, and nobody would answer questions or anything. And then the Financial Bureau made Fifth Third Bank give me my money back. But when they were giving me my money back, the defendant had it transferred into his account because originally it was supposed to go to his account. After it was lost with Fifth Third Bank, I sent all kinds of letters and everything else, so they would return that $9,000 to me. Now this is another part to that. When Fifth Third Bank had my money and they didn't return it, the defendant was pressuring me because he needed the money to get more lawn care equipment. And so I gave him $9,000.
Did you ever see any lawn care equipment?
He showed me some pictures, but it didn't even occur to me that he may not be telling the truth about the lawn care stuff. I mean, I was so wrapped up in thinking, okay, I'm gonna get my business started. I'm taking care of my son, totally distracted because I have to think for me and for him. And I didn't think that the defendant would scam me. Yeah, he showed me some pictures. He showed me pictures of the trailer. He showed me pictures of the riding lawnmower, and then things need to
I can show you pictures of a rocket ship. It doesn't make
exactly. I swear my mind frame, I don't know where it was because
I'm just breaks my heart, Ms. Tuckerberry. Miss Powell, was Mr. McKinney ever served in this case?
1 second, Your Honor, let me check.
He was served by me like 3 times and then
Hold on, ma'am. Hold on.
Okay.
This is not legally.
Okay. Your Honor.
Yes, ma'am.
He was served, like I said, by me, and I turned those papers into you all, into the court, and they're filed. And then Miss Kiera sent them one last week.
So the affidavit of service the date for that is March 26th.
Okay, and who was he served by?
Certificate of service. I'm sorry, the certificate of service was March 26th. The affidavit of service was filed on April 14th. And then we did send service as well for the Rule NISI.
Okay, when I said who was he served by, so the original complaint was served by the sheriff's office?
Yes, ma'am. I'm looking into it to double check, but I believe so.
Yeah, did he file an answer of any kind?
He has not responded to the case at all.
Okay. All right. So the court is going to grant you the amount of $73,960. That's $65,700 in principal, $4,000 in attorney's fee. Well, no, you don't have an attorney, so I can't give you attorney's fees.
Yeah.
$537 in court costs, and you're asking for prejudgment interest. And I'll go ahead and grant you whatever prejudgment interest you're entitled to. Okay. All right. Now, Miss Tuckerberry, listen.
Yes.
Carefully. I don't understand why people don't understand this. But you don't ever give anybody money on just a say so.
Yeah.
You don't ever exchange money for anything that doesn't have paper backup with it. If somebody tells you, well, I'm going to start a business, and they have a business, well, you want to know, okay, well, who've you worked for before? Can I get Can I talk to your clients? Can I see your work? Can I see the actual, because you weren't even giving him money to start your own business. You were
Right.
giving him money to support. If somebody's telling you, I'm working 3 jobs and I have all this money, doesn't it, think about now what sense it makes to be working 3 jobs and you can't get a loan and you don't have any money to do something else that you working 3 jobs and your money is tied up in
Mhm.
other stuff, but you don't have any money and you got to come to a vulnerable person who's taking care of another vulnerable person and take their money.
Yeah. All my life, I've seen all kinds of scams and everything else. I didn't think I was in one.
People get excited when folks start talking. I've seen it so many times. Well, we're going to start a business and we're going to do this. And they get that hype language.
Yeah.
But they never see profit and loss statements. They never see tax returns from his current business. They
Mhm.
never see anything in writing that says, I have successfully started a business and I am going to use the money in the right way. Everything he showed you, he could have gotten off the internet.
Yep. Yeah. And I didn't think that all the way until the part where he told me, well, I think we should just like separate and all of this kind of stuff. And I'm like, what about the lawn care? It never entered my mind for this person that he would do this. It just never. And the pictures, you know what I'm saying? I saw the
Okay,
pictures. Okay.
so ma'am, I'm going to give you the judgment. I don't know that you're going to be able to collect it, but if I were you, I would get an attorney to help you collect.
Okay.
Because you're not going to be able to navigate what it takes by yourself.
Right. Your Honor.
But number 2,
Okay.
this sounds like a classic romance scam or fraud. So you may want to report it to the police. I know sometimes people get
Okay.
embarrassed, but he may be doing this to other people.
Okay.
If I were you, I'd file a police report. So just go down to the police station or call the non-emergency number. Because
Okay.
he not only defrauded you, he defrauded your son. Your son has a disability, so he's taking money from a vulnerable person.
Yes.
That's somebody we need to get off the street.
Okay. Those numbers that you quoted to me, can you quote them to me again?
It'll be in the order. We're
Okay,
gonna send
thank
you a
you.
copy of the order, but yeah, you're not entitled to attorney's fees. 'Cause you don't
Okay.
have- But like I said,
Mhm.
collecting money is hard. So you may wish to get you
Okay.
an attorney. Because if he's doing things that are fraudulent, that money ain't gonna be easy to find and he's not gonna willingly give it back.
Okay.
All right, but Ms. Tuckenberry, please, please, please. Like, think critically about stuff.
Mhm.
He may be talking sweet in your ear, but think about the fact that, why would a man who is so successful need your money?
Right. Absolutely.
All right, so we'll get the order out to you.
Okay, thank you so much, Your Honor.
Welcome. All right.
Now we're moving to Washtenaw County, Michigan with Judge Simpson. And it's a whole week worth of stuff. We're starting on the 4th, moving to the 5th, and then to the 6th, looking at the highlights of every day. All starts right now.
Court calls case People versus Tasha Beavers.
Conrad Siller on behalf of Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Beavers. Ms. Beavers, please state your name for the record.
Tasha Beavers. Okay. What are we doing in this case?
Your Honor, regarding the pretrial, we're requesting an adjournment for some ongoing investigation.
I will adjourn the matter to June 8th, 2025, 9 a.m. As to the bond violation.
Your Honor, I did have a chance to speak with my client regarding the bond violation. I believe that she wants to admit to the violation today. Is that correct, Ms.
Yes.
Beavers? I did advise her her right to a hearing. Regarding bond and sentencing on the bond violation, would like to make some statements on behalf of my client.
Yes, go ahead.
Regarding her health, she is dealing with some health issues. She's dealing with kidney cancer and is on significant medication for that. She has an appointment with her kidney doctor on the 6th. I believe they're working towards getting a transplant. She's very concerned that if she is in custody, that she may lose that appointment and may lose that process, or lose her line in that process. She did speak to her agent at Community Corrections regarding the test, and she does have an appointment for CCOP this afternoon at Community Corrections. So she is working on getting into a treatment program. Her son lives with her if she's in custody. She supports him by paying the bills, rent, groceries, things like that. If she isn't taken into custody, it may impact her son and his ability to stay in that home. We are asking that the court consider continuing her personal bond, ordering her to report to Community Corrections for the outpatient program, and perhaps adjourn sentencing out to see how her progress grows in that program.
Well, here's the concern that the court has. On May 21st, first of all, she's here on a possession of direct paraphernalia charge. On the 21st, she tests positive for benzodiazepine, THC, cocaine, fentanyl, and other opiates.
She did make me aware that she has prescription medication that she takes. You did provide a prescription to Community Corrections for the benzo, I can never pronounce, but thank you, Your Honor, as well as the opiates. She did also want the court to be aware that because her kidneys are not functioning properly, they don't flush her body as quickly as normally functioning kidneys, and that may be why she's continually testing positive for the other illicit substances.
I understand, but the problem is that they shouldn't have been there in the first place. And then, so that's on the 21st, 8 days later, and I'll take your word for it, on the benzodiazepine and the opiates, they're still present in their system, THC and cocaine.
THC.
And so, anything you want to say, ma'am?
Well, THC takes a minute to come out, and I am trying. I have a appointment today. That was as soon as they can get me in.
Well, you have an appointment? What do you mean with?
With the outpatient treatment.
She did schedule that with Ms. Dozier at Community Corrections. I believe it's reflected in the violation report.
Well, maybe if you put together a plan, I'll consider some other remedy and something else to do. I understand she may have the medical appointments and the other things, but at this point in time, this is absolutely unacceptable. Defendant's bond is revoked, defendant is remanded. Thank you. My bail.
One remaining question. If we do get her assessed and get her a bed, can she be released to inpatient treatment?
I will consider release to inpatient treatment.
Okay. All right. Thank you, Your Honor.
Thank you. Ma'am, you're gonna have to stay back. Case, People versus Stephen Johnston.
AP Richard McDonough for the people.
Or Yagi, Assistant Public Defender, with and on behalf of Mr. Johnson. Your Honor, may we approach on this matter?
Yes.
Thank you, Your Honor. So as I mentioned to the court, I am asking that Mr. Johnston be allowed to be released to inpatient treatment. That is a priority of his. He acknowledges the issues he has with substance use, and he is eager to get treatment. I know Mr. Johnston is not happy about my request for an adjournment of the PCC, but I think it's important because I do think there is some additional discovery that we should see before he makes a decision whether or not to waive his exams.
Adjourned probable cause conference, June 26, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor. I did just want to repeat the response.
Yes.
We did discuss this at the bench. I understand that at our last hearing, the court was very clear with Mr. Johnson about the fact that there was no contact with the DV victim related to this other case, and who's also involved in this case as well. And his phone privileges were revoked at the jail, and that he was having absolutely no contact with her whatsoever, including third parties. Since that time, we do have a report and transcripts from some calls apparently made with other people's pens, that he has contacted third parties. Well, he's attempted to call her 6 times, and also use third parties to make requests that they get in contact with that same victim. So tell her that he loves her. I can make a further record of some of the comments, but Mr. Johnston is apparently under the impression that because he had and still has consensual contact with her in his other case, that trumps any orders given by this court. I would ask that the court make it very clear, since in one of those calls he stated that the county, quote, fucked up his orders. And I won't repeat the comment that he made about Your Honor, apparently in this case, but, I'm
sure it was very affectionate, so go ahead.
Sure. Affectionate with all the F's. So he, Mr. Johnston is under the impression that, again, there are erroneous orders made. I would like the court to be very clear with him that no matter what order he has in any other case, a revocation of phone privileges, as well as no contact with this victim, including third parties, regardless of his location, including should he be released to inpatient treatment, as counsel's order states, all prior bond conditions remain in full force and effect. That does include contacting this victim, including with third parties. While we may not have a recording from him while he's in treatment, it will still be apparent to us because, quite frankly, Mr. Johnson has been anything but subtle since he's been having this case pending. So I'm just asking for a reminder of those conditions. And I don't have any issue with the release of treatment. However, I would ask, well, I'll just leave it at that. I'm asking the court.
Thank you. I just received the transcript of these calls, actually, just very brief, not too long ago this morning. I am going to have a very detailed and thorough meeting with Mr. Johnson later today about his bond conditions. He does have 2 different cases. Obviously, she's not listed as a victim in this case. It's the circuit court case where she's the victim. And so I will make it very clear with Mr. Johnson in our meeting later today. I will, and I would request the actual calls from the state instead of just the transcript.
Mr. Johnson, you understood what I ordered? Not asking whether you like it or not. You understood what I ordered?
I kind of understood, Your Honor.
Yeah. What's the kinda?
I've never been in like court like this before, so I'm new to this, like being in trouble and stuff like that. So I'm not all familiar with the terms or wording and ways of effect of. I watch a lot of court TV, yes, but I don't understand personally, no. I do have like a question of like what does a no contact order mean, Your Honor? Like, if you can, like,
No contact order means that you are not to have contact with that named individual, either directly or indirectly through third parties in any way whatsoever. You are not to have contact via any electronic communication, whether it be telephone, email, social media, or anything like that. And you are also not to mention them on any social media platform.
Is that clear enough for you?
Yes, yes, Your
And
Honor.
understand something. I don't believe in coincidence. So if there's contact, I'm gonna believe that you purposely did it. Either yourself or through some third party. Because even after I ordered it the last time, and I don't think you don't know as much as you're trying to pretend before me that you don't know, because of some of the stuff that you were saying going out of the courtroom. Also, if true, your behavior indicates that you are sophisticated enough to get somebody else's pen to try to make communication in an indirect fashion. So you understood exactly what I said. You just didn't like it. So hopefully now you do understand. Do you?
Yes.
Do you have any other questions regarding what I mean by no contact?
No, Your Honor.
I don't want to hear any more that there is any type of use of somebody else's pen to do some direct or indirect contact with the victim, because you're not supposed to be making phone calls at all. You've lost that privilege. Anything else from either side? June 26, 2025, 9 a.m.
Your Honor, would the court consider a 1 week adjournment, or is that not enough time?
If you want, if that'll work for you.
Um,
If you're trying to get I don't know about the discovery. That's the only thing I'm trying to.
Understood. Do you know?
I'll give you the 1 week.
Okay.
The 911 call problem.
June 12th,
Thank
2025,
you.
9 a.m. Bond is continued with its condition and my admonition that you need to follow what I order. Thank you. Have a good day. Case of People versus Aaron Washington.
APA Richard McDuffie for the people.
Pardon? Yeah. Oh, okay. What's your name, sir?
Mr. Washington.
We're ready in this matter, Your Honor. Along Brown, Deputy Chief Public Defender, appearing within on behalf of Mr. Washington. Today's the date and time set for the probable cause conference. We are respectfully requesting this matter be set for preliminary examination. We do believe all of the discovery is present.
I was just telling Mr. Brown, I didn't get a chance to tell him that I checked in advance with the OIC regarding availability. And he stated that he could be available either next week, June 10th, or July 8th. He will be out the intervening 3 Tuesdays.
Two. Yeah, I can set it.
It was just supposed to be
Everybody's gonna be ready.
but she tried to go man tax too.
Okay, so we'll work on this. So July 8th was one of the options, Your Honor.
Yes,
And what was the other?
it was June 10th. It was, yeah, it's Tuesday coming up.
June 10th, please. Your
June
Honor.
10th?
Yes, please.
Okay, everybody be ready on that day. June 10th, 2025. 9 a.m. That will be before Judge.
I don't want to adjourn.
That's before, that's before Judge Barr.
That's the next day.
I just want to check the council. Are we sure about June 10th?
Yes.
Okay.
Yeah, adjournment will be July 8th. We ain't trying to do that.
No, I'm not adjourning.
So you want June 10th, right?
Yeah,
See?
that's preliminary.
Okay, cool. That works. That's pretty
You
cool.
two all set?
Kinda, we're getting there.
Kinda, no,
Baby.
I ain't got all day.
Try to figure it out. Try to figure it out, Simpson.
June 10th, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you.
Am I waiting?
That's who I was calling.
I'm not gonna talk to you
You have to talk to me.
unless you have good.
I'm asking for a really quick thing, but.
Denied. Court calls the case People versus Benjamin Coleman.
Alexander on behalf of the people.
Good morning.
Good morning.
Sherilyn Foster Tucker on behalf of Benjamin Coleman.
Benjamin Coleman.
In today's date, time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
All right. Well, being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Ann, can you hear from all? I need to talk to you.
I know. Don't be surprised.
Okay. Court does call the case People versus Anika Skib.
Ashley Lonnie for the people.
Kyle Burrell on behalf of Annika Skib, who's approaching the podium and will be standing to my right. Ms. Skib, once you get up here, please introduce yourself to the court.
My name is Annika Skib.
And we're this morning for final settlement. This time, people are unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Ms. Skib has a tether on. Will she be able to go by today, or does she have to wait till tomorrow to go get the tether off from community corrections?
Keep it.
What do you think?
As much as I'm attached to it, Your Honor.
Literally.
Or it attached to you, right? She should be able to go over and get it taken off once they know that the case is dismissed. So before you leave here, you can turn your friend back in. Right?
Thank you, Judge.
Here. Court does call the case of the People versus Daniel Sims.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Sims, who stands to my right. Please state your name for the record, sir.
Daniel Sims.
And Your Honor, we have reached a resolution in this case in exchange for a plea to an added count 2 of retail fraud in the 3rd degree, a 93-day misdemeanor, $500 fine or trouble amount, contrary to MCL 570-356E4. That being retail fraud in the 3rd degree, retail fraud in the 2nd degree, currently charged count 1 will be dismissed.
That is correct, Your Honor, and that is what Mr. Sims would like to accept today. I do have the paperwork with me, the assigned advice of rights form. And I do have the police report if the court would entertain a no contest plea. But I do understand the tardiness of the police report.
Pardon?
I do understand I am turning in the police report tardily.
Yeah, is he going to plead guilty or no contest?
He was asking to plead no contest, Your Honor.
Pardon?
It don't matter either which way, I guess.
He does understand. He is fine to plead guilty, Your Honor. He's ready to proceed either way.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead, lower your hand, state your name.
Daniel Sims.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the 3rd degree.
Yes.
It is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep.
Yes?
Yes. I'm sorry.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
I am now.
Okay.
I am now.
Fair enough. At the time of this offense, were you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
August 10th, 2024, at the location of the TJ Maxx store on Carpenter Road. Yes, at 3158 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I walked out the store with a backpack.
Okay, so you went into the store, correct?
Yes,
And you took a backpack
yes,
and you walked out without paying for it?
yes,
The store was open to the public at the time?
yes.
You didn't have anybody's permission to take that property, did you?
No,
And this backpack that you took was backpack that was offered for sale by TJ Maxx?
yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's?
Your Honor, it was more than just a backpack. There were other items as well, but if the defendant will stipulate to the amount of restitution being $249.86, I don't have an issue with the factual basis.
I believe it would be proper to accept this court's plea, Your Honor, yes, and we
Yeah.
would stipulate to that amount.
Court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Cyan Taylor.
Ashley Lundy for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record. Cyan Taylor.
Your Honor, we are set this morning for final formal comments and 10 people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. You want to keep your tether or you?
No, sir.
No?
No,
You sure?
I'm positive.
It looks great though.
No, don't feel good.
All right. You heard my instructions. Probably
Thank you.
go over there and get it taken off. Thank you.
Thank you.
Court does call the case. People versus Elizabeth Wilson.
Ashley Lundy for the people.
Good morning, Your Honor. Attorney Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, stating the right. Your name?
Elizabeth Wilson.
All right, you're good. All right.
Your Honor, today is the date and time for final formal conference. People are able to proceed. I understand that the defendant is going to be accepting the original offer of pleading guilty as charged with a prosecutor's deferred sentence. I'm sorry, she'll be pleading no contest if the court will allow. The police report I sent over this morning, I do apologize for the lateness, but that is something that we could not avoid, I think, in this case. So that is our request today for the plea.
That's correct, Your Honor.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and self you got.
I do.
Go ahead and lower your hand, state your name again.
Elizabeth Wilson.
She signed an advice arrangement.
She did, Your Honor. At our arraignment?
She signed a new one.
I do not believe so, Your Honor.
I don't have, I do. That she signed on December 11th, 2024. Does she recall signing that?
Do you recall when you originally signed this document? If you're originally-
Did I? I don't know.
You did. I don't know. And we also discussed.
Well, I'll pass it. She needs her rights and then I'll call you back up.
Yep.
Sorry.
It's Elizabeth Wilson.
Ashley Lundy for the people.
Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, standing to my right. State your name for the record, please.
Elizabeth Wilson.
Did I have her sworn already? All right, you have been sworn. And ma'am, it's this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased times the value of the property by $500. That would become the maximum fine. Understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand is desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea?
The police report, Your Honor. That would be, oh, I'm sorry, oh, the base, oh, concern for prospective civil liability, Your Honor. Caught me sleeping there. I was ready for it. I was ready for it. I thought you wanted me to give this exact number. I was like, okay, okay. Proceed.
Well, thank you. My court. Appreciate you giving me permission. Ma'am?
Yes.
To that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-16-502. Any objection to the court having reviewed that report?
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Satisfied.
Satisfied, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report and determination of any restitution, and prosecutors deferred. Sentencing in this matter will be July 9th, 2025, 9 a.m.
Your Honor, can I get an alternate date on that? I have I'm supposed to be in Rochester at 8:30 that morning.
July 23rd at 9 a.m.
That works.
July 23rd, 2025, 9 a.m.
Thank you, Your Honor.
Bless you. Bond will continue.
Thank you.
Johnson and Mac and Drukas?
And Foster Tucker.
Really?
Not me.
And Pete.
And Mr. Livingston. I kind of feel about that.
I really don't want to talk to any of them.
I know. We're gonna have a good time.
All right, let me.
We only need 5 minutes.
You always say that, and then it's a half an hour later, and I don't know what the heck is going on.
We actually are on the same page this morning.
What?
We're on the same page this morning.
Are you in the same book?
Yes, very close.
Probably right. I'll take them. Court is standing recess.
All right.
Court does call the case of People versus Angela Walker. Soon as the prosecutor comes back in full B. And look over this. Heading back to the restroom. No, it's okay. It's okay. and acknowledge you were back there with me all the time. Everybody else got a chance to.
Yes,
All
Your Honor, I'm actually wanting for the people.
All right, this is on the Angela Walker.
Yes, Your Honor, there is an offer available to the defendant to plead to an added count 4 of operating while intoxicated with an occupant under 16. And I'm going to have to get that PAC code here for you.
And that is correct. And Sherilyn Foster Tucker on behalf of Angela Walker. Ms. Walker does intend on accepting that plea.
If she does plead to that added count 4, there will be dismissal counts 1, 2, and 3. People are not opposed to a no upfront jail sentence as long as the defendant remains compliant on bond. The PAC code is 257 625 7. A is in alpha 1.
All right, maximum.
Or I.
Maximum penalties on that.
It is a 1-year offense, $200 to $1,000, 30 to 90 days community service, cost of prosecution, rehabilitative programs, reimbursement, and other various license sanctions to the Secretary of State.
Oh, very good. This is going to be a guilty plea.
Yes, Your Honor.
Oh, that's very good. May I have her sworn?
Do you solemnly swear or affirm the testimony you're about to give to be the truth, whole truth, and nothing but the truth, so help you God?
Yes,
Lower your hand and state your name.
Angela Walker.
All right. Ms. Walker, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant under 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Court could also order your vehicle immobilized. Court order you to pay the costs of prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes,
All right. And understanding that, do you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep,
You signed an advice of rights form, is that correct?
yes,
Any question regarding any of those rights?
no,
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be waiving or giving up those rights.
yes,
You understand you're giving up your right to appeal of right.
yep,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today in court on the record that it's making you plead guilty to this charge?
no,
Anybody threaten you or coerce you in any
no,
way? You're doing this voluntarily?
Yep.
Of your own free will?
yep,
And because you believe that you are indeed guilty of this offense, ma'am?
yes,
November 23rd, 2024, at the location of 3211 Rosefield Drive, were you operating a motor vehicle?
yes,
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
yes.
All right. Do you recall what you had and how much?
I had beer,
Okay.
like 3.
All right. Were you stopped by the police or was there an accident?
I was stopped.
All right. Why'd the police stop you?
There's an agitated event at my house and I walked away from it, and I guess my sister called and told them what car I was in.
Okay. Gotcha. Okay. And you're not disputing the right of the police to stop you in this case, are you?
No,
All right. And were you ultimately arrested?
yes,
All right. Were you taken to the hospital for a blood draw?
yes,
And what were the results of that blood draw?
I was 0.1.
0.10.
Yes, Your Honor.
All right. You have any reason to dispute those blood test results?
No,
All right. And at the time that you were operating this motor vehicle, was there a minor in the vehicle?
yes,
And how old was that minor?
8,
Date of birth?
August 23rd, 2016.
All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 4. Counts 1, 2, and 3 are dismissed pursuant to the plea agreement. Defendant is referred to Von Schwartz. Ron Swartz for an alcohol screening and assessment, and the victim's impact panel. Sentencing in this matter will be July 7th, 2025. July 9th, 2025, 9 a.m. All right. Bond with its conditions will continue.
Thank you, Your Honor.
Start the process if you stop down at my probation department on your way out there on your lap.
Okay.
All right. Thank you, Ms. Wong. Court does call the case of the People versus Carl Tinsley.
Ashley Lonnie for the people.
Good afternoon, man. Please, this honorable court, Kareem Johnson on behalf of Mr. Tinsley.
State your name.
Carl Richard Tinsley.
All right.
You understand the date set up for final settlement conference. The victim in this case is currently incarcerated. My office reached out to his attorney about his interest in participating with the case, and we have not heard back yet. So at this time, I'm not able to represent that I'm ready to proceed. So I'm not ready to proceed.
You're gonna ask this matter be dismissed without prejudice.
People being unable to proceed at this time, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Let's call the case. People versus LaShawn Carver.
Ashley Lonnie for the people.
Good afternoon, Your Honor. Edward Drukas on behalf of LaShawn Court.
LaShawn Court, right?
Thank you.
Good morning.
Good morning.
Afternoon.
Yeah, I guess it went into the afternoon. Good afternoon. All right. What are we doing?
Your Honor, today is the date and time set for final settlement conference. We've reached a resolution where the defendant is going to be pleading to count 3, attempted assaulting, resisting, or obstructing a police officer, with counts 1 and 2 being dismissed. At the time of sentencing, the prosecution will not be opposed to a fines and costs sentence.
That will
That was no contest.
That would be a no contest pleaded.
And the basis for the no contest.
Lack of memory.
All right. Very good. May I have her sworn?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, with the truth, so help you God? Confirm. And just state your name. LaShawn Court, right?
All right. Ms. Court, it's this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
You understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. The first thing is it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Understanding all of that, still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights for today. Is that correct?
Yes.
Any question about any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're waiving or giving up those rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Counsel, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2371. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
You are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be July 9th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue.
Okay, thank you.
Thank you, Ms. Cartwright.
Yeah.
Okay, let me call this.
Yes, please.
Sycamore Meadows versus Caleb Peak.
Good afternoon, Your Honor. Attorney Carrie Zanon, P67-390 on behalf of plaintiff.
Your Honor, Jill Bauer, P 69260 on behalf of Ms. P, who is also present.
Kayla P.
Thank you. All right.
So we, in our conference room breakout session, we talked about, Ms. P applying for $5,000 to pay for some of the repair costs. And then, once the repairs, they might be able to move her to a different unit, but I'm still working on that part. So needless to say, Judge, I have settlement authority today to do pretty much what we discussed. The only thing I would really like, and I'm putting this on the record, is like a 12-month probationary period as long as no more lease violations, but I'll do it as a 4A. We'll do a conditional dismissal. That's where I'm looking. I just want to put you on notice. That's kind of where I'm looking at. And
Okay, I think, Your Honor, with that huge piece being out of the way, we can work out the details.
I think so too, Judge. I think that we're finally in a spot where.
Yeah, and I'll submit that rental assistance application today. And I have made a preliminary inquiry about it. Ms. P, do you, since this was all like happening on the record, do you need to talk to me about anything before we finalize this? Or are you okay?
I think the way you can talk to her, like, let's lay some, because my client wants to go over it as well. I was gonna put something together, send it to my client, make sure she's okay with it, and then I'll send it to you, and then you guys can go from there as well.
Generally, Ms. P, what we're saying is we're gonna try to get 5,000 of rental assistance for you. And because of that, Sycamore is gonna agree to pay and try to rehouse you. So in general, does that sound good to you? Okay.
All right.
Somebody owes me lunch, Judge. Just saying, somebody owes me lunch.
I have a protein bar.
No, but I'm thinking something much better than that.
How long will it take you to get all the paperwork and everything done?
Do you want to do you want to do 2 weeks, but we can submit something?
Yeah, that's what I was thinking, was 2 weeks, if you're okay with that.
So what I'm gonna do is I'm gonna indicate cases settled as stated on the record. Order to follow.
Wonderful.
And then I will just set a control date of, I'll just set a control date of June 27th. What time is or Sycamore cases on that day?
Ms. Zanin on that day, I believe is at noon.
All right. So, but if you settled it,
Of course, Judge. Yeah. Thank you.
And I know this, Ms. Zanin, if you could get me a letter today saying that that's what she owes, I can submit
Oh,
it
yes,
with.
I absolutely, I can do that.
All right.
Wonderful.
Thank you guys for working it out. Do
Thank you, Your Honor.
appreciate it.
Have a wonderful.
You do the same. James English versus Shauna Snyder. English would go over here. Is there English?
Yes.
All right. We're down that side. Snyder?
Oh.
All right, come on. Yes, come on. You're over here, right here, just right there.
Over here.
Yeah, right there. All right, this is a termination of tenancy case, and folks, what's going on?
We moved her in because she was getting evicted from her other residence. Her husband moved out on her. And we allowed her to move in without no lot rent, no fees. And she come out one morning and started taking pictures of me, implied that I was stalking her. I feel uncomfortable with her being there.
Okay. All right. What's the relationship between the parties? Any?
She's the daughter or friend of my wife.
That's why we allowed her.
Hold on a second. Okay, so who are you?
I'm his wife. I'm also on lease. That's why we allowed her to move in. We're trying to help her out. She's been there 3 months.
Okay, hold on. Just
Physical altercation.
all right. So still trying to figure
It's
this
just
out.
a bad situation all the way around.
Okay, that's not what I was gonna ask. Who is she related to?
She is my daughter.
Thank you. That's a simple answer I was looking for. All right. So your daughter moved in because you got evicted from your other residence, is that correct, ma'am?
That's not correct.
Okay, so what happened?
I was living at another residence with my husband at the time, and he was abusive with me, so I had to separate from him, and then he left the house. He was being evicted. I wasn't on a lease at all. But
Got it.
I was gonna put on there, and then they allowed me to come with them and stay for, I said it was just temporary. I just needed like a little temporary. I wasn't gonna be there forever. I just needed to figure out,
What you were gonna do?
yeah, because all what I was gonna do got messed up. You know, like with everything, and
Okay, and
then
go ahead.
he has been very inappropriate, the way he acts around me. I can't even take a shower in that house. I can't do laundry. I always have to have my phone because I don't feel comfortable.
Okay,
And then she called the cops on me after that and said, "You're not locking my husband up, B word." I got
Okay.
that on recording
okay,
that day.
all right. So, but you don't have a lease there, correct?
No, I don't. I don't want to
Okay.
stay there either. You
Okay.
know that.
So when did, ma'am? So when are you going to leave?
As soon as I can. I was thinking the first is probably the soonest I can.
Did you bring a lot of property with you?
I have a bunch of it in storage and I have a bunch in that room in that house. And I have a dog and a cat and they know that. It's really hard to find like a room to rent with pets and they want
Okay.
$1,000 a month for a room.
I gotcha. So when do you folks want her out?
Today.
Okay, that's not happening.
Yeah,
What's a reasonable time for her to get out of the premise from your perspective?
7 days.
Okay, by law, she at least gets 10.
Okay, she get 10.
What's the attitude with this? I mean, you guys moved her in. You realize the circumstance, at least she's saying that she was in, and you got to give her time to move out. You let her move her stuff in.
We did, but we wasn't expecting for her to start calling me a stalker and all that. I feel uncomfortable with her in my house now.
What would be a reasonable period in your mind for her to move?
10 days.
Okay. You guys can maybe sit there and think about what you're doing. Whether you like family or not, you got to deal with it that way. You let her move in. So think about a reasonable time for her to get out. You've had to go through this. I don't want to hear from you right now because I'm going to get up and leave this bench because I'm not happy with any of you.
Are you
You
speaking?
figured what did I just say?
That's
What did I just say? Court's going to stand in recess.
All right. One minute he wants you to speak.
You want to know what? You want to know what? You're going to be in contempt and you're going to go. You are not even a named party on this case. You might want to go out there and sit down. Go out there and sit down.
No.
Now.
No problem.
Now, go. Just go. One more word and you're out of here. One more word.
No problem, ma'am. Hey, don't, you go, okay? Okay, now you can turn.
Want me come up there?
You can wait till he comes in and calls the case.
Huh?
You can wait till he comes in and calls the case, or you can just sit and take it out.
All right.
You can come back.
All rise.
You may be seated. We're back on the record in the case of English versus Snyder, and both parties are here. And I'm just gonna try to resolve this because apparently the parties can't do it themselves. And I'm not gonna try to, there's whatever water under the bridge. You're saying you want to the first?
Yes, please.
You are saying, sir, that you want our statutory times 10 days and you're stuck on the 10 days.
No, she can stay to the first, it's just as long as she agrees to get out.
Okay, I appreciate that. All right, and that's a reasonable way to handle this. So what I'm gonna do, this is a termination case. I'm gonna grant a judgment for possession after hearing on this case. The writ date, July 1. Okay, now, so they can act so that both parties understand this, okay? On July 1, they can file what's called an order of eviction or request for an order of eviction to have you forcibly removed from the premises. I don't think you want to put anybody into that.
No,
Just-
I'm not even trying to get evicted. I don't have any evictions on my record.
Okay. You have to file with the court, sir, a judgment form, and you have to fill that out for my signature. Okay, so you can, I'll get you guys out of here. You can pick one up at the counter, file it with the court. I'll sign off on it. All right, that will give her until July 1 to vacate the premises. All right. Anybody unclear as to that? All right.
I'm not.
You're clear.
I'm clear.
Okay. For you, sir, I'm going to tell you because what you don't want to do, and you may want to inform your wife of this, is to in any way, prior to that date, try to do anything that looks like it's your own self-help in terms of getting her out. Okay?
Right.
Okay?
But she's still not allowed to have company over, right? She's in the past.
Okay, look, that's not before me.
Okay.
I can't, I do a lot to rule people's lives. I can't tell who's going to be, I'm not going there. Okay?
All right.
The only thing I can tell you is that as of that day, that's that. Okay? Now, I'll give a suggestion while I can't order it. Okay, young lady? How old are you?
I'm 31.
Okay. You can like your parents, you can not like your parents, you can not do whatever. But when things got bad, that was somebody that gave you a roof over your head. Okay? And so it doesn't mean you even have to talk to them. But I think it's sometimes important, and I think I'll call you a kid because you are somebody's kid, right?
Right.
That these days, sometimes they're just not respectful of that. So while I'm not ordering it, I just say to you, just be respectful. They don't want you to have.
Trying to be, and like the whole time I've been there, I followed all the rules. And they let me have one person over, only one person per company, and then they took it back after all that. They're like trying to.
Okay. Well, I get it, but this, what you guys are telling me are what parents and kids have been dealing with forever, right? And so, when my daughter stays with me,
I can tell you, she's thinking I'm changing. I'm thinking to myself, that's what I said all along, but from her perspective, I'd let this happen and then I changed something. I didn't change anything in my view, but I get it. Okay, so, just do it and try to work through it, okay?
I'm trying.
Okay, and the same thing for you. Just try to work through it. Sometimes it's better if all of a sudden at one given moment you want to say something, just don't say anything. Count to whatever. Just don't say anything. And then maybe 30 seconds down the road, you're not quite as unhappy about it. You just try to figure it out. Okay?
You say I gotta get some kind of form?
Yeah, you got to get paperwork. Ask them for a judgment form.
Judgment.
At the front counter. All right, then you just got to fill that out. Okay?
All right, thank you, sir.
All right. Thank you. So I can trust that you two will walk out of here peacefully and not
I won't knock her.
go at it in the hallway. Huh?
No.
Either just can you two walk out peacefully, or do I have to have escorts?
Just
All right. Then here you go. And you sit there. You sit there and then we'll get you up. Okay?
Yeah.
All right.
Clifton Johnson is first.
We're here. You're ready on.
All right. I think we have a sentencing hearing today
Yes.
here in 24 CR 2150. Come forward.
We're ready.
And you got to be up here to be ready. Who's on this, Sarah? Stop. Oh, you're the defendant, Mr. Johnson?
Yes.
Correct?
Yes.
Okay, and Langston Adams is your attorney.
Mm-hmm.
And the state's attorney is here. Earlier, you pleaded guilty to, I think it was just paragraph 1 of this indictment, right?
That's correct, Your Honor.
Which was 3rd-degree felony, charging you with injury, causing bodily injury to a disabled individual. And pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it? And are there any corrections or changes to it, beginning with the state
No, Your Honor.
and defense?
No. No, no.
Then it is made part of the record for all purposes. All right, the agreement is whatever sentence shall not exceed a cap of 6 years imprisonment. So I think what we have here is several options. The defendant could be placed on deferred or unadjudicated probation for up to 10 years in length of probation. He could be found guilty, sentenced to no less than 2, no more than 6 years confinement in prison, and that could be suspended and he could be placed on probation. And finally, he could be sentenced to no less than 2, no more than 6 years confinement in prison. Those are about every option available in the Code of Criminal Procedure and the Penal Code. So is the defense ready?
Yes, Your Honor.
Go ahead.
Your Honor, with this particular case, what it really stems from, and I know you've read the police version of it, but let me give you a little bit more into that. This is his biological daughter. They've been having problems with her posting naked, nude images online. So that's a problem that he's been having with his biological daughter. And they've done things to address that, counseling, talking with her, working with her over and over and over again. Well, on this particular night in question, his current paramour, and she's to my right, and she has a hand up in the courtroom. As you can see, that lady is disabled. She's in a wheelchair, and my client is taking care of her. He's her support. He's everything. The biological daughter got mad at her for for disciplining that was taking place and actually hit her. Now, Judge, I remember a time, and I'm quite sure you do as well, when a child typically would not raise their hand to an adult. And I'm not justifying my client's actions, but when the child with a history, with the promiscuity that was going on, and then the child assaults a disabled lady. My client did take her into, I believe, the adjoining room and discipline the child by spanking. Now, I'm not saying that the extent of the spanking was justified, because I'm quite sure many of us in this courtroom have been spanked. I mean, I remember myself when I was in high school, it was common for the coaches, assistant principals to give corporal punishment. And I'm quite sure even when you was in school, Judge, you dealt with corporal punishment to an extent. So I'm not saying that, the extent of the corporal punishment was justified, but the circumstances.
Well, what wasn't justified that you think?
The lashes and the body, the thing went too far. I mean, I know I've got corporal, and I'm quite sure you have too, but I haven't been hit like that. And
so you're saying something was wrong with that?
Yeah, no doubt about it. I'm not defending that. I'm saying something was wrong with that. But what I'm saying is
what was the defendant striking the little girl with?
I think it was a fishing rod.
A fishing rod.
Right. I think it was, and don't get me wrong, Judge. I mean, okay. I know in my day when the coach got us, it was a
fiberglass rod.
No, it was a powder. I got it. And
I'm quite sure you fiberglass rod here in this case.
Right. Absolutely right. Right. But I'm saying,
anybody want that? Anybody want to get struck by a fiberglass rod?
No, not at all. Not at all.
I'm not asking who would want to strike Rife, because everybody's hands would be raised. But all the defense bars raising their hands.
But I'm quite
talking about something else.
But I'm quite sure he got a powder when he was in school.
Being is there's some disturbing facts.
Absolutely. And I want to deal with those, Judge. You absolutely.
How old was the child? What's the child?
This is a teenage girl, right?
How old was the child at the time of this?
17 now.
She was 16, Your Honor.
Okay.
Yeah. So, Judge, like I say, I mean, I'm not defending the extent of it. I'm just saying the circumstances in which he lost a little bit of control.
Are there any photographs of the injuries?
There are, Your Honor, on a USB drive.
It states that she had lacerations and cuts on her back and upper right shoulder.
She was also missing a fingernail.
Say that again?
She was missing a fingernail.
Oh, well, I thought you said just finger. Fingernail? Did she lost a fingernail in this?
Now, my client is gonna say that had nothing. This fingernail had nothing to do with him. That's a separate. That had nothing to do with the spanking.
That's the least of my concerns on this. Yeah.
Right.
Let's put the fingernail out.
Right.
Let's just take that out of the equation.
Right.
It's still disturbing.
No, it's no doubt about it.
Okay.
And where I'm going with this, Judge, is that corporal punishment should not go to that extent. The only reason I just brought it up is that many of us in this courtroom have had corporal punishment. But what I was trying to say, Judge, is the circumstances of this is the little girl hit an adult, and the little girl had been posting nude pictures of herself, and the parent is reacting to that. And the extent that the parent reacted was a little bit, well, not a little bit, was too far. Okay. So with that being the case, our argument for asking you to put him on deferred adjudication is a two-fold argument. The first argument, and I had Mrs. Whitmore as a Whitmere as a witness.
It's W.
Yes, as a witness, and she wanted to talk to you directly. I know she's in a wheelchair; she's not wheeled up. But what she's asking you for is just to have sympathy for her particularly. That's the caregiver. She's in a wheelchair. The only reason she's in court today is because he drove her here. I mean, if he was to be put in jail today, she doesn't even have a ride home. I mean, he's taking care of groceries, taking care of this, taking care of that, and she wants to talk to you directly.
So what's the point?
The point is that she's going to beg you to put him on probation and to have mercy on him, and that would be the point of her. So, and she wants to talk to you directly.
Okay, but you're saying he needs to be put on probation so he can take care of her?
That's one, that is one, that's.
Is that an important reason?
Well, for a lady that can't, is not mobile, yes, for her, it's super important because she can't get around.
And do you feel as though that's necessary here in this circumstance?
Well, in this particular circumstance, why I was asking, in addition to that, is that he went too far in disciplining his child. But
We're talking about. I mean, the grand jury indicted and apparently the defense is admitting liability here and culpability. The question is, what do we do and what message do we send out?
And what I would suggest that you do is put him on the intensive supervision program, get him the anger management, order that he takes parenting classes, order that he takes the battery intervention classes, order him to take classes that help him to cope better with those circumstances. But at the end of the day, I think that this was a situation where he went over the edge because the little girl hit the disabled lady and the little girl was posting naked pictures online. And I think as the father, he overreacted. I mean, that's the only way I can describe it. He overreacted in the discipline of her. Now, I'm not saying corporal punishment is bad. I got corporal punishment when I was young, and I'm quite sure you got it too. But
Never did, but I can understand how you would get it regularly.
Well, you probably got it to school.
No, we all. I think we all.
Yeah. So
should. Everybody makes mistakes.
True.
And especially children have to learn from mistakes. And but how you deal with it. I never had a fishing rod slapped on me.
And I have
back and my buttocks. I've never had that. That's it's a deadly weapon because in the manner of its use, it can cause serious bodily injury.
That is correct, Judge. And that's why I'm not defending
that's a problem. That's the issue. That's the aggravating factor here.
Absolutely. And to address that, what he's telling me now is that I believe, you know, in your bond orders, you have no contact with the victim. That's typically what you do.
Yeah.
When I talked to him before, he's telling me, now I'm only going to know what he's telling. He's telling me that he's not having contact with the girl. And with her being 17 years old and she's fitting to be an adult, at least according to what Mrs. Scott lives. You know where she lives. I don't know.
The grandmother.
Somewhere else.
She lives with her grandmother.
She lives with the grandmother. So there's not going to be a danger to the child because he's not around her. And in one more year, she's going to be an adult, 18, doing whatever.
He's not a danger. He's not a danger to the child unless he gets around. That's the statement. I mean, I can order this. I can order this, but.
And he didn't defy your order by going around her, at least to my knowledge, and talking to him. And that's why I was asking, Judge, that if he gets that treatment, and I know your probation is high success, he's going to be successful on that probation. He's not a danger to the child. And this was just a parent that just went over the edge with his little girl that was posting naked pictures online, and the little girl who hit a disabled person. The discipline went it went too far, but to put him in jail for 6 years, I don't think is the solution to this. I think the solution is to get him the help with the classes, the treatments, the battery program, the anger management program, conflict resolution program, have him check in with you. And that's part of one of the reasons, I had talked to him about, and he wanted to do this cap because he knew that the cap would be totally in your hands. And I said, hey, talk to Judge Stevens, talk to him yourself, and he would be open. I can't tell you what he's going to do, but he'll be open to what you got to say. So I'll leave it with him. And she just wanted, and if you don't mind, Judge, she's in a wheelchair. Do you mind if she just says one word from there?
What is she going to say? Yeah, we can't control outbursts, but what is she going to say?
I anticipate that she's going to beg you to allow him to have probation.
Is that right?
Yes.
Okay. That's conveyed to me.
That's what I anticipate that she's going to say. Okay. And then as far as him, I don't want to put any words into his mouth. I'll let him speak to you directly.
Oh, let me ask, hold on. The defendant was convicted in 2014 of burglary of a home.
That's true.
What was the sentence?
4 years TDC.
What other criminal history does the defendant have?
He has quite a lengthy misdemeanor history, Your Honor, of possession and theft, and then he's got an unauthorized use of a motor vehicle that he got 1 year state jail for, the burglary of a habitation that he got 4 years for, the aggravated assault with a deadly weapon that he pled to a lesser and got 180 days state jail, and then the new injury to a child disabled.
Okay, so this is his fourth felony offense.
Yes, Your Honor.
Absolutely. Fourth felony conviction, or not. It's fourth felony case that he's subject to sentencing on. And this goes back over for 30 years. Misdemeanors in 96 case. And it doesn't go without notice that in 2018, it looks like he did 90 days in the county jail for assault of another person. So this isn't his first assault either.
No, he also had the aggravated assault in 2018.
It's his third assault.
And Judge, I'm not hiding from his past. His past speaks for itself. It's just in this particular incident, and I know his past, you can't learn from it. His past is what it is. You got a little girl.
It's never in the past.
No, it's the current.
What the famous written saying is.
Right. And like I said, I'm not justifying his actions. I'm not trying to say that it was right. But what I am trying to say is you got your daughter posting pictures of herself online, and then that daughter strikes stepmama. He overreacted to that.
Yeah, I wouldn't have gotten a deadly weapon and assaulted the child.
Yeah, I agree with you on that. You're right.
All right.
But that was the circumstances.
No, that's why we're here.
Right. Right. And that's why I was asking you to consider him for probation. It's those particular circumstances of this particular case. This is not one of those cases, because I do CPS cases too. I mean, it's not one of those cases where you got the parent who, for example, got the cigarette and torturing that child, or the parent that's not feeding the child. In this situation, you got the parent that was disciplining the child after the child had struck a disabled woman, and after the child was posting naked pictures online. And I think he went too far.
But it's the legislature cites it as a third-degree felony. It's not the least serious type of felony either.
Yes, you absolutely
third-degree
right.
felony where you can go up to 10 years in prison according to the legislature. So it is set forth in the law how important it is and where it places, and the elements is because a child was one. And in this case, what's lucky is that I guess that a deadly weapon wasn't alleged in here. I don't know what difference that would really make, since being a child makes a aggravated crime, but well, it would have been aggravated assault. It's a different type of crime. Aggravated assault with using a deadly weapon could have easily been alleged, and it's a second-degree felony, more serious. But you can't harm a child in this way. Then children should be disciplined. That's how way they learn and correct behavior. There's nobody's debating that. You just don't use a deadly weapon in the with the device as the instrument to discipline someone. What state says?
Your Honor, the defense has really failed to mention what I think is a key part of this case, which is that the child has intellectual disabilities. Just because the child...
Tell me exactly in this case what we're talking about.
The child suffers from... She is mentally slow. She had a hard time talking to police. This is why it's a third-degree felony, was because of her intellectual
Does she go to a
disabilities.
special program in school? Does she attend a special program? Or
She was supposed to be. I don't know if she is now.
what about that, Langston? Do you know anything about that?
With your daughter, because he know better than me. Are you aware about any kind of intellectual? Because they're saying that she you address that. You can address that yourself. I mean, it's your kid. You know better than me.
With my daughter, I got her like February 22nd or February 28th of 2022. My daughter was.
Say that again.
He said February
22nd or February 28th.
Of 2022.
The
What do you mean you got your daughter?
You got
I got my daughter back.
He didn't have custody.
I didn't.
I never lost my rights, but she was in foster care. She was staying with a lady named Miss Ella Davis. She got put into foster care because she ended up on the second floor by herself at the age of 1 or 2. And I never.
Why is she in foster care?
She's not in foster care now.
Why was she in foster care?
Because her mother, she's a drug addict. She left her daughter with her mother, which her mother passed. She left my daughter with her mother, her grandmother, and my daughter ended up on second floor. And the neighbor, I found this out when I was working. The neighbor called and they ended up taking my daughter into CPS custody. But the lady didn't want to separate her from her brother and her sister. So she was with this lady for so long, since she was 1 and 2 years old. She was with this lady up until the age of 14. I didn't get my daughter to after that because my daughter, she did something to the lady. She cursed the lady out. She wilded out with the lady. So the lady sent her to her mother. But her mother was not supposed to have her because she don't have no rights over her. So I ended up getting her at that age of at the age of 14. I ended up getting her then. But when she was with the lady named Miss Ella Davis, she never told me that my daughter was like this. I never knew it myself. I thought she was just, normal. I never knew she had this problem or that problem or anything like that. I never knew none of that.
How old are you right now?
I'm 40. I just turned 47.
Go ahead.
So, and don't get me wrong, when she was in this foster care with this lady, I was making my duty to take the time out of my day when I was working to go spend time, check on her or getting to know her or whatever, because every person in school told her they told her she didn't have no daddy. So that kind of broke her a little bit, but as me showing in my physical form, by me showing my face, by me letting her know that you got a daddy that loves you, you got a father that's gonna be there for you. But all this other stuff that's going on, I never knew none of it at all. Ain't nobody never told me that. They kept me in the blind. So I had to go off of what I know, and by learning her when she was with me, that's the only way I learned her.
So in summation, what you're saying is that if the state is suggesting that the child had some type of a mental issue or delayed issue as far as mind, whatever, and that was documented, that's something that you did not know about. So you responded.
I have no recollection.
You had no information about that. Is that right?
Yes, I have no recollection of it. I thought she was okay. I have no information on anything but her just being my daughter. That's the only thing I knew. And by me putting her in a government federal program, but she did the pornography on a federal government program. So the school called me and told me I need to check her computer.
Right.
I need to do this, or I'm gonna have federal charges on me. I can go to federal prison for what she did. I didn't understand. My daughter did this for age 14, 15, and 16.
Right, but your response to the state's question that was brought out is that if there's any documents that go to mental issues or whatever, you weren't aware of that.
I wasn't aware at all.
Anything else?
No, well, that's all I got, Judge. And like I say, he and his a spouse that's here is basically begging for mercy from the court. And basically you had a father who overreacted when the child punched her and when the child was putting those naked photos online. And it was an overreaction. It shouldn't have taken, shouldn't have hit her with the rod. Injuries to her back should not have occurred. Many people get caught like I have, like you and many people in court, but none of us got anything like that. And I know I've never got hit like that in my life. I've never had where I was bleeding, never in my life anything like that happened. But what I am saying for the mitigation purposes is that he just overreacted as a dad. I mean, he went too far considering the circumstances in disciplining his child. And there's nothing that the state is saying to refute that this was about disciplining the child.
If I could, Your Honor, I can refute that. I just haven't had a chance to speak.
You'll get a chance. Anything else you want to know?
That's all I want to say.
Okay. By the way, the pre-sentence report had been tendered. Were there any corrections or changes to it?
No, yeah.
Other than that, then it's made a part of the record for all purposes for this sentencing. Okay, stay.
Your Honor, I would like to point out what the victim said about this case to police when she ran to a restaurant to ask for help because her father had beaten her 30 times with a fishing rod, is that they had believed that she had stolen some popcorn from a corner store. Not that she had assaulted her stepmother or that she had done anything with any pornographic videos, but that she had made popcorn and that he had saw a juice box in her room, and that's what caused him to beat her. When officers responded to the medical center, they estimated that he hit her 30 different times with that fishing rod. This was not corporal punishment. This was abuse. This was torture. And then in his statement to probation, he said, "I'm upset and disappointed from what my daughter has put me through." Not any remorse for anything that he did to his own child, his own disabled child. He wants to have probation to help another disabled person when this is his 4th assault case and it's his 4th felony offense. I see no reason why we wouldn't give him any less than 6 years confinement.
Anything, any summary you want to make?
Well,
or response? You have
what a quick response is that we said it was discipline for assaulting a disabled person. The state said it was discipline for something with food or what have you. But at the end of the day, this was discipline, and she can testify if you want her to that she was hit. She's in the courtroom. If there's any doubt that this child hit an adult, the person that was hit in the courtroom, I said, Judge, you can ask her right now. She's here. She'll tell you she was hit. I mean, you're looking at her. So, I mean, she's available. There's no doubt that this child punched an adult disabled lady who's in the courtroom. And like I said, he overreacted. He shouldn't have gone to the point that he went to, but this was about disciplining this child for the pornography and for the assault. And that's why we asking the judge. I don't think that he's gonna leave this courtroom and be a danger to anybody, go break the laws or go do anything like that. He just want to take care of his wife, who he drove up here today. And matter of fact, if he went to jail this very second, I don't even know how she would even get home. I mean, I don't know. I mean, I don't even know how she would even get home. He's been doing a good job with taking care of her. And I told him, I said, hey, I don't know what's gonna happen. It's a cap of 6 years. The judge will give you deferred. He can put you in jail for 6 years. He can give you 2 years, 3. I told him, I say, I don't know. I say, but at least one thing for certain, whatever it is, Judge Stevens is going to be fair. Talk to him and just make your case to him. And I'll close with him. Is there anything you want to tell Judge Stevens that I left out?
Before things seem to be right, this is, I don't want to be there for her because she needs me, regardless, you know. I'm the only one that's there to do what I need to do for her. I'm not too much worried about me. It's just her. I gotta get her out the bed, help her out the bed, help her in the shower. I got to do all that. And she can't, it's hard. She done failed over 5 times. 5. Because she really, she, she, she been through so much with the person she used to be with before. And it really made it bad for her. She's wired up on her right side. It's hard for her to walk. I got to cook. I wash clothes. She don't do nothing. I do everything that's possible that I need to do for her.
All right, I'm going to ask you just a couple of questions. How many misdemeanor convictions do you have? I mean, it's your life. No one would know better than you.
3, 4, I'm not sure.
3 or
It's been so
4,
long.
you think?
It's been so long. I don't keep up with it.
Well, it was as recent as 2018. But you were 3 or 4?
Yeah, I think it's 3 or 4. I'm not
10. 10. There are 10 of them. And let's see. Most of them drug offenses, and then there's assault causing bodily injury was the last. Oh, what about felony offenses? How many felony convictions do you have? See how close you are to the correct answer, guessing your life's history.
Possession weapon.
What does that say that you don't even know the answer? What does that say about you? I tell you how many I have. I mean, that would be an impact in me because that should be a major part of your life. But
I think I got about 4, Judge.
I have 3 and then this one. So 3 convictions. But the point is that that's 13 convictions in courts of law, non-class C misdemeanors and courts of record. But that's far too many for anyone. But there's so many you can't even remember. And in this case, the defense, you don't give a lot for your attorney to help you on in these circumstances because nobody finds injuries to a child amusing, much less appropriate. It's completely and totally uncalled for. Yes, they need to be disciplined, but you don't take a deadly weapon like a fiberglass fishing rod and beat the child with who ended up with, let's see, multiple welts, obvious welts on her back, both arms, backside of her legs, bleeding, swelling, and redness of her injuries. Nobody feels sorry for you. Nobody feels sorry for you. And you've said in your whole set of defense and statements here, the motivation was her actions, her actions. The pre-sentence report that's in evidence, you're 45 years old, 44?
47.
Yeah. You were a daily synthetic marijuana user for over a decade until just a few years ago, according to you. Synthetic marijuana makes anybody out of their mind. So that's the role modeling that child had to deal with from you. Multiple years of synthetic marijuana, cocaine, weekly cocaine use for 8 years until you were 30. You admitted using LSD, ecstasy, marijuana, monthly since you were 18 years old until a month ago, according to the pre-sentence report. Diagnosed with depression, symptoms of anxiety, attempted suicide. You participated in patient treatment for mental issues at Ben Tom. What kind of role modeling is that for the poor child? I have children, and they're going to emulate what their parents' examples are. at the very least, you get poor parenting of the year. You're a terrible parent. And so it's the child's fault that she wasn't acting appropriate. And so you beat her. You've got to see how bizarre that is and how missed of the mark you are. You've got it backwards. You're responsible.
Yes.
Not, I feel sorry for the child. The child really didn't have much of a chance because role modeling is the most important influence on a child from the parents. Yeah, and now you're saying you want to do something that is humane for the lady that you're taking care of, you're living with, and that's your get out of jail free card. You can assault a child after all these years and years of abuse to yourself as well as to the child, and then you want to be able to say, I got to get out of jail free card. I got to take care of somebody. Now you are practicing humanitarianism. You hadn't done it to your own child. Your own child doesn't get it. Your own blood. My goodness. Why would you be so worried about someone else? The creator gave you the child. You chose a partner, which is okay. But how did you do with what gift the creator gave to you? You abused the child and self-abused yourself with narcotics years and years and years and years, which didn't give the child any hope or role modeling opportunity to make wise choices. This all explained. All right. Yeah, you were in jail for 7 days here in this, according to this record, in accordance with this case. When you were in jail, who was taking care of the lady?
No, there was nobody there.
So she's able to take care of herself when you're in jail. Well, there she is, and you were in jail for 7 days. How did she survive?
My neighbor came and checked on her. But my neighbor works, so my neighbor was able to check on her or whatever. But when she needed somebody to check on her.
Okay.
So I had to have my neighbor to check on her.
If nothing further, the court's going to find the defendant has pleaded guilty here to this third-degree felony of injury to a child. Voluntarily, knowingly, intelligently, there was sufficient evidence supporting the guilty plea to find you guilty beyond a reason, based upon State's Exhibit 1 that was introduced into evidence. I now find you guilty beyond a reasonable doubt of this third-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. That is one of the options that the court has. I want that just to sink in for just a moment. So you go to prison for 6 years. Your paramour, the lady you're taking care of, she's stuck without anybody to take care of. The child, father's in prison again. And then all you're doing is making a mess. Another chapter in the same book of here I am making a mess. The court's going to do this. Okay, I'm going to suspend the 6 years, place you on probation for 10 years. There will be terms and conditions of probation that you sorely need for dealing with other humans, as well as your family that you seem to disrespect and not have a humane attention in dealing with. Here's the probation orders. There needs to be some kind of program that moral recognition therapy, some comes into mind. Parenting class comes to mind, which you've wisely, the probation has already offered to place in your mental health services through Spindletop. Enter in successfully completing the battering intervention and prevention program. You're going to submit to a substance abuse assessment because it's hard to believe anyone with years and years and years of chronic abuse to drugs telling us the truth and being forthright. Seldom does that ever happen. And there will be other terms and conditions of probation which you need to follow, which ironically are in your best interest and to help you be a better person. Why you haven't done this yourself. And you had to come into this court as a defendant assaulting your child for strangers to have to fix the mess in your life is inexcusable, but it happens all the time in here. That's what we do. That's not all. When you harm a child, it goes with a price. You're going to serve 180 days in the county jail, and we'll do that on weekends. You're going to have to work some way to have this lady taken care of. But you don't avoid responsibility and punishment that's due by using the helplessness of others. Like, no, she didn't have anybody to take care of. You got to figure that somebody's got to help her. For those, you report on her before 6:00 p.m. each Friday. Release you on 6:00 on Sunday, and you'll do that until 180 days are served. Do you understand? That's the price that this court sets because children should not be harmed, especially tortured. You understand what has happened today, so this is what is called justice. This court deems it to be the appropriate method, and it has its seriousness for the consequences and the circumstances of the harm to children and your self-harm that you have performed on yourself by not respecting yourself, by abusing drugs and committing so many offenses. You need to fix all of that while you're still alive. Anything else?
I don't have anything. I have something, Your Honor.
Yes.
When does the jail time begin?
It's Friday.
This Friday.
Mhm. So you've got 48 hours to figure out a care method for the lady for those 2 days. Do you understand? Anything else? Please see the probation officer.
Thank you, Your Honor.
Okay, we call cause numbers 23-41343 and 23-CR580. And the defendant is Desmond LeRae Harper, and then there's a new case or two.
Three, Your Honor.
Three new cases?
Yeah, Your Honor, that's great.
Cause numbers 24 CR 84, aggravated assault with a deadly weapon, 85, unlawful possession of a firearm by felon, and 24 CR 86, aggravated assault with a deadly weapon. So 5 total cases and 3 new cases and 2 motions to revoke probation, correct?
That's correct.
All right. The defendant is welcome. Bring the defendant in, please. Thank you. Hey, Mr. Harper, if you'd be so kind, take a seat right over there. Thank you.
Well, why I'm sitting down for, sir?
Right over there with Mr.
I'm saying, why am I sitting down? I'm asking a question.
You don't want to sit down?
No, it ain't. That's not what I'm asking. I put emotions. I got I gave you petition for release.
Yes, sir.
Because of delay.
Yes, sir.
I'm still doing, I do a speed trial with case law.
All those motions I've reviewed, they are denied.
You can't
We're ready
deny
for
it, sir.
Yes, we can, sir.
No, you can't. They gotta go to Austin.
No,
And
that will be done
no.
after
With case
these
law,
hearings.
with case law,
That would be
case law.
done.
No, you not gonna sit up here and tell me that you're gonna violate my motherfucking rights, nigga. I don't give a fuck about that. I don't give a fuck about that. I don't care about that. I don't give a fuck about you, none of y'all. Fuck y'all. Fuck is you talking about? This is my motherfucking life, white boy, you Egyptian pharaoh. Cause this law right here tell you, federal congressional enactments authorizing or empowering any of the defendants named here to the place detention, detained on parole with no apparent reason at all to cause plaintiff to be detained on the pretext that he might be convicted for the new offense, then seek he will always be in violation. Motherfucking a parole takes from plaintiff the presumption of innocence and just violates the 14th Amendment. All right, here, bitch. I'm not doing none of that.
All right.
So get up out of here,
You're taking outside.
Yeah,
Back to
bitch
the
ass
set.
nigga.
Go back to the
Fucking
set.
pharaohs. Fuck y'all.
Go back to the set.
Fuck you pharaohs. Yeah, get me up out your courtroom,
Go back to the
bitch.
set.
Yeah, nigga. What you gonna do, nigga?
Just make sure.
Fight or
that-
something? You gotta get on like this. What you gonna do, nigga?
Make-
Bitch. Yeah.
Make sure that the speaker is on so he can hear. Mr. West, you made sure we took care of competency matters earlier, didn't we?
Your Honor, I was just appointed on this case like 2 days ago, so.
Do you know anything about this?
And I've got all
Yes,
this
sir.
covered for me and Mr. Boyd to talk. I know about the facts of the case. I know about the details. I spoke to my client a little bit. I know that at one point he was evaluated for competency and was found to be competent at one point. But I mean,
Well, there's a competency evaluation back in December. And we did that because the similar actions that he displayed here in vulgarity, obstinance, anger, and raving lunacy type statements are similar to what we caused Dr. Ed Rapon, licensed psychiatrist, to evaluate the defendant, who submitted a report December 9th, 2024, that states that the defendant is competent to proceed to a resolution of his legal issues. Is there any reason why you feel like we need another report at this time?
Your Honor, due to the fact that he is very uncooperative and not willing to work with us, even when I was talking to him, he's not wanting to move forward with doing anything. He's just ranting. I would argue, I know Dr. Pons found that he's competent, but I would suggest that he's incompetent due to the fact that he is unable to assist his counsel in moving forward with this trial.
Yeah.
Or this hearing and or these trials coming up. So I would request to have it evaluated again, but I'll leave that to the court. The court's had more experience with them than I have. I've just only been on the case 2 days, so I don't have months of experience like y'all have with them.
And Your Honor, this is his third or fourth attorney. This is.
It doesn't have anything to do with Mr. West. I understand that.
Your Honor, I just meant, I think it's its way of stalling and keeping this case. He, in the underlying case that he was placed on probation for, he contacted the witness, tried to keep her from testifying. That's why he was given a deferred, because we couldn't get her. He's done the same thing in this case, contacted her from the jail. There's nothing on those jail calls that suggests that he's incompetent in any way. He carries on normal conversations with his mother. He doesn't get his way, and he comes in here and thinks he's going to delay the proceedings, which he has several times now, because he knows we have a hard time getting the complaint.
But once again, I would prefer Dr. Rapon, since this was 6 months ago, Dr. Rapon follow up with an evaluation.
Well, when we won't be able to get the complaint, sometime in the future. And
but once again, we could have had a hearing, I guess, earlier, but 6 months have gone by. Mr. Boyd, can you pay attention, please? Would you be so kind? Just don't. I mean, that's just like what I just had to deal with him, turning your back to me.
I was looking at Mr. Larry. See, I don't know what to do. I mean, I don't know what to do on that.
Well, what we want to do is whatever whatever way we handle it, we want it to be a secure decision that is not reversed. I want to make sure that all the i's are dotted and t's are crossed. What is the problem in having another evaluation at this time? I mean, I think Dr. Rapon could make it happen within 48 hours or so, but where do you see a problem?
I guess just my idea is that he acts like this every time, the difficulty in then scheduling a.
But I know, but how many times have we, at the end of the day, how many times have we had this motion to revoke probation hearing set for a hearing? Is this the third time?
I think it may be the fourth, where he acted out at least 3 times prior to this and first for me. So that's just what I'm concerned with, is that I know we're very busy in here and that it may take, let's say it take another 6 months to get to a hearing because of.
Why would it be? Yeah, I mean, if now he's got our attention, again. Do you remember the dates of the other hearings?
Probably had, if we had an evaluation done in December, I would bet January. And then maybe February and then March is when we had to have him to solitary, that's not able to speak. He wouldn't be a priority, and I think we would. I tried again, it was April. And we did today because it was actually.
I need to, we need to have dates so she can pick up the record. So I can look at the record of the times. And I'm not showing in this when hearings were held or attempted to be. I see where there were some resettings for a particular date, but there's nothing that shows what happened on those dates here.
The other than the one where we get the memo to the jail.
Well, here's the deal. It is as well is that's the most important thing is what do we do with proceeding with a hearing with him not present in the courtroom? Because his presence in the courtroom is volatile, vulgar, obstinate, angry, and I've remembered this over and over again. So what do we do, Mr. West and Mr. Boyd? Since they have a right to be heard.
I must keep my position that he needs to be evaluated because he's unable to effectively work with anyone, much less me.
What do you say, Mr. Moore?
Your Honor, the Ninth Court of Appeals had a case very similar to this, in which an individual kept trying to delay the proceedings. Again, there's not a jury here. I think that was part of the argument. It's not influencing a jury in any way. If that individual is giving, the individual is given 2 or 3 opportunities to come out to behave himself. He did not. He was then placed in a holding cell where he could hear the proceedings, and it continued from that point on. And the court held that that was.
How does he confer with his attorney?
If the attorney needs to ask him.
How does he confer with his attorney? Anybody know?
If the attorney needs to ask questions, the attorney can go and stop the proceedings, go back and ask a question of his client. But if you disrupt the court so that you cannot hold the proceedings, otherwise you're voluntarily absent yourself from the proceedings because you're creating the situation, not the state.
What are the other dates of the hearings? So I can put that on the record.
I have July 31st, 2024, Your Honor.
Okay. Hold on.
Yes, sir.
7/21.
7/31, Your Honor. Yes, sir.
Okay.
And then March 19th, 2025.
Okay.
January.
And those are the 2 that hearings were scheduled where we had it. There were 2 times before where there was announcements, but that was in.
During those announcements, I think he was obstreperous.
Yes, Your Honor.
We weren't even on.
Okay.
I want to say that was for January.
Okay. So 7/31 of last year and 3/19 of this year were the 2 hearings for MTRPs?
Yes, Your Honor.
Would you be so kind? Well, those right again. let me look, we're gonna take a short break. I want to review the transcript on those hearings. And make a record of that. We're in short recess. Yeah, I have a plea on Chelsea Ship. Okay, let's do that. Yeah.
She's in custody.
Chelsea Ship, please.
A new at 6, a Jefferson County grand jury has indicted 2 people for first-degree murder in connection to the death of a 16-year-old girl. 24-year-old Chelsea Ship and 22-year-old Cody Arnold were arrested back in March for the murder of Caitlin Stone. Now, according to a probable cause affidavit, Ship shot Stone while she was asleep in a trailer where the 3 were staying. Ship allegedly shot Stone after Arnold expressed that he could get in trouble because Stone might have been pregnant. Now, officials found Stone's body covered in a black garbage bag in the trailer on Cobb's Corner, which is near Fannette. Jefferson County detectives were tipped off by a woman Ship allegedly confessed to. Arnold and Ship each being held on a $1 million bonds.
And here is Chelsea Ship. Does she need to be sworn in? All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie Ship. No. That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here? This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here now?
Yes, sir.
Is it because of the writing? Judge?
Yeah.
It's 40 years, Judge.
Okay, I'm gonna redo that, Jim. I know. I wish we had this pen for everybody. This pen seems to work better on the pad
Yes,
than
sir.
others.
Thank you.
And
Thank you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years imprisonment. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. How do you plead to this indictment, charging you with this first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Macon, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Ship, you are pleading guilty to this first degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true. It states So help you God, out of states Exhibit 1, and the court supports those representations with positive findings that are in the record that restate those admissions. I hereby find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it?
No,
Is there any,
no, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, now?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Take Mr. Peterson, take Mr. Patterson's file too.
For the latecomers, I am sorry. That's it. I've been going for almost 3 hours. There's a rewind button and there's a lot of show to go through. It was a long week. I showed a lot of stuff. I don't have anything else to show right now, although I do have videos. That wasn't all of it. There was other stuff that happened. So, ladies and gentlemen, I'm your lone wolf Oozle. I'm your host for this here end of week court case review, and I am your curator for the gallery here on YouTube, where we watch court cases and discuss what we see in each case. Here, sorry ma'am, sorry. It was really happy. I'm happy to see everybody today. Marty, Jill, Mama, Duncan. I'm going to read through everybody's names I see here on the screen. Black Boeing, Cynthia, Katie, Johnny. Did I say Jill, Northwest? I'm not sure. Bro, Guinness, good to see you. Good to see everybody. Happy to have you here. You know how we do it. We do this every weekend on every Saturday, about 11 a.m. Central Standard Time. That's noon Eastern Time. We're doing brunch together, having a little bit of coffee. And ladies and gentlemen, every weeknight, 8 p.m. Central Time, 9 p.m. Eastern Time, we all get together and we watch the court cases of the day and discuss them and chat. Come by and hang out with us. Come by and hang out. And in the meantime, keep an eye out for other videos, because I'm definitely going to make a couple more videos. There's definitely a few more coming out. So, ladies and gentlemen, thank you very much for joining me. I'm your lone wolf Oozle. I will see you next time. I am out.